Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I thought we'd have a look at the case of the Queen and Justin Green. And this is a bit of a fun case because it's a case where the court has very little patience for someone's BS and goes through in some detail taking it apart. So we can see what that looks like. This is also in the context of a weapons trafficking set of charges. So let's go ahead. So background. The defendant is charged with 29 firearms offenses. Each count relates to a different handgun purchased by the defendant, although, as will be seen, there are several repeated charges and several that do not fit the weapons purchased by the defendant. Of the 29 counts set out in the indictment, 23 of them relate to firearms purchased by the defendant. 7 of the charges against the defendant are for transferring a firearm contrary to Section 99 sub 1 of the Criminal Code. The balance of the charges are for possession of a firearm for the purposes of transferring it, contrary to Section 100 sub 1 of the Criminal Code. So again, these are weapons trafficking offenses. He's alleged to have transferred these unlawfully or to have had guns for the purpose of transferring them unlawfully. On December 6, 2010, the defendant was issued a license that authorized him to legally purchase restricted and non-restricted firearms and ammunition, which is what we commonly call an RPAL. His first purchase of a firearm took place on January 3rd, 2011, and his final purchase of a firearm was made on September 14th, 2012. The defendant's license required his 23 firearms to be safely stored at the defendant's father's house at 7669 Kittredge Drive, Mississauga, which is where he was living at the time his firearms license was issued. The weapons have all gone missing and are now not located there. So, 7 of the 23 guns have been either found at crime scenes otherwise unconnected to the defendant or seized from persons otherwise unconnected to the defendant. In short, the Crown submits that the defendant transferred the 7 recovered firearms knowing that it was illegal to do so, and that he was in possession of the other 16 firearms for the purposes of illegally transferring them. The defense submits that the defendant intended to keep the 23 firearms as a personal collection and that they must have been stolen from their place of storage at 7669 Kittredge Drive and were not intentionally transferred to anyone by the defendant. The defendant is 24 years old and a student of philosophy at the University of Toronto. He was arrested in October 2012. So the parties have entered into an agreed statement of facts, which has greatly facilitated the trial process. The following facts are taken from that statement and are therefore not controversial as between the Crown and the defense. I'm going to skim over this, but an agreed statement of facts is fairly common. I mean, it doesn't happen all the time, but sometimes it's a way of simplifying the trial process where you just agree that certain things have happened, and then that way you can move past that and argue the issues that are contentious. So this saves time. It may save the defense money, but as a defense, from the defense perspective, you don't want to give anything away in your agreed statement of facts that maybe you could have fought and might have provided a defense. So there's always tactical considerations with this. But typically, if something's in the agreed statement of facts, it's not contentious because the Crown can probably prove it without too much difficulty. So they start out with the example of a Beretta 92FS. On January 3rd, 2011, just less than a month after receiving his license, Justin purchased his first firearm, a Beretta 92FS 9mm handgun. And that came out to $914 with 1 box of ammunition. Already, I mean, who goes through 1 box of ammunition? Whenever the media is talking about guns, they're always like, oh, and he had, hundreds of rounds of ammunition. And I go, yeah, because he's somebody who shoots his guns. I'd be a little more suspicious of 1 box of ammunition. I don't think I've ever bought 1 box of ammunition at a time. So because of the firearms regulations, Justin was not authorized to transport the Beretta until he received his ATT from the Chief Firearms Office, which he got 4 days later on January 7th, 2011. This is fairly common. If you're not a gun owner, you've probably never had this experience, but you go in, you buy a new gun at the gun store, and then they have to phone you to say, oh, by the way, now you can transport it home. And the gun store has to hang on to it in the meantime. So in May 2012, a year and 4 months after his initial purchase, the Beretta, the defendant began purchasing a series of weapons. Over the next several months, he purchased 22 handguns from 4 different stores in the Greater Toronto area. The agreed statement provides So he had a job with Famous Players and with Walmart, and his total income for May was $1,318.44. So big money. And in that month, he spends total amount of purchases comes out to $1,318.70. You'll notice that one of those numbers is bigger than the other. That's a bit of a problem here. And June, his total income is $1,596.05. And he buys several guns. I'm just trying to see what the total is. In any event, there's several months, and in each of these months, he's earning, $1,500, $2,000, somewhere in there, and he's spending more than that on guns. I like firearms. I like buying new firearms, but it's kind of hard typically to buy more guns than you have income. I mean, some of us try, but anyway, so the 23 firearms in total over the several months cost him $17,461.84. And they say they have an estimated street value of between $48,200 and $54,200. So moving on, the defendant testified in his own defense, which you're not required to do, but may sometimes be necessary in order to get your evidence out. But if the Crown can't prove their case without your evidence, they can't make you testify. That's your choice as to whether or not you decide to testify. So in this case, he did. The defendant testified that at one point in late high school, he developed a desire to become a lawyer, and then while at university, he had an ambition to open his own school of philosophy. He also said that he's a gun collector. Indeed, he presents himself as not just a student of philosophy, but as a self-taught student of firearms. He stated that he has acquired substantial knowledge about weaponry over the years, and that obtaining a firearms license made him feel like an expert. I have a firearms license, but a firearms license doesn't make you anywhere near an expert. I'm not, my expertise in terms of firearms law, I've got a fair bit at this stage, but, there's plenty of people who can go circles around me in terms of actual firearms. So just getting a firearms license, you don't need a whole lot of knowledge for that. He apparently became fascinated with weaponry as a youth while playing video games for hours on end. He testified that this fascination continued into his adulthood and motivated him to become a licensed firearms owner. As he put it on the witness stand, philosophically speaking, I always liked the idea of firearms. To be clear, there is no evidence that the defendant is much of a firearms user. Although there is some confusing testimony as to whether the defendant ever belonged to a gun club or firing range, neither the Crown nor the defense says that the defendant is in the habit of firing his weapons very often, if at all. That one kind of hits close to home because I don't make it out to the range as often as I'd like, but I'm not sure frequency is necessarily sort of a key thing here. But let's continue and have a look at what all they're saying is going on. He's not characterized himself as an avid target shooter or gun sports enthusiast. Indeed, he testified that in the summer of 2011, after he had his license and had bought his first gun, he contemplated applying for a job with Brinks as a security guard, but that he's a poor shot and could not qualify. Rather, the defendant has characterized himself as a passionate firearms collector. It was clear from the defendant's testimony that he has studied up a bit on the firearms he purchased. He expressed admiration for various details of the weaponry in an effort to demonstrate that he's an enthusiastic collector and a handgun aficionado. He testified that, I look at firearms as being beautiful. I definitely like the aesthetic beauty that goes with firearms. And again, that's a sentiment that many people might have. There's many people who collect firearms because some firearms are quite beautiful. They say, although the defendant made a point of speaking like a firearms devotee, he did not relate the title of any particular book about firearms or the use and history that he has read, nor did he tell of any museum he has visited, or historical exposition, or even contemporary gun show that he's attended. There's no evidence that he ever purchased any firearm other than a currently manufactured, mass-produced handgun. His professed aesthetic interest does not extend to antiques, rare or unique weapons, or any other type of collectibles. I mean, I can certainly demonstrate that I've been at some gun shows. I've been photographed at some of them. I mean, gun shows are fun. You get to go and look at the things that are there. So already the court is kind of going, your story isn't checking out, buddy. Let's keep going, because the judge here puts a lot of effort into taking this apart, and it's kind of fun. The defendant indicated that much of what he's learned from firearms came from discussing his various purchases with the clerk in the gun shops where he shopped. The agreed statement of fact, however, contradicts that testimony. It provides evidence from Andy Giraldi, the salesman at Al Flaherty's outdoor store, where the defendant bought 15 of his 23 firearms, to the effect that Justin Green knew what gun he was looking for. Mr. Giraldi didn't have to show him multiple guns. He appeared to know what gun he wanted and asked for it specifically. Now, Al Flaherty is probably not happy about being in this particular case, but they're a long-standing gun store. They have an excellent reputation in the community, and they wouldn't have knowingly gone along with any of this. And I'm sure that they were super, super upset to learn, of their minimal connection to this. But yeah, and they appear to have been happy to provide evidence against him. So yeah, they specifically contradict his notion that he's there sort of looking around at things. And they say he just comes in, he buys what he's looking for, and he leaves. The agreed statement also summarizes the store clerk's perception of the defendant's purchasing habits. He recalled that Justin Green would come into the store, buy a couple of guns, and leave. He said that he was not a customer who stayed for a long period of time. Without putting too fine a point on it, the defendant's knowledge of firearms is not exactly what one would call encyclopedic. Rather, it is what one would call Wikipedic. I love this line. This is, I have an appreciation for judicial snark, and this is some fine judicial snark here. So it's a really beautiful line, and I love this case, if nothing else, just for this line. So carrying on. He has enough knowledge about the weapons he purchased to suggest that he has carefully read an internet-style blurb on each one. He could therefore explain, in brief, what makes them distinctive or potentially attractive to an owner. By way of illustration, he stated that he didn't realize the cost, but he was anxious to get his first firearm, so he bought the Beretta 92FS on January 3rd, 2011, only weeks after receiving his license. Now, it's not unusual that somebody would buy something within weeks after receiving their license. Many gun owners go and buy their first gun, maybe even within days of getting approved for their license. But then again, his income was not terribly high here. So they say, although he may not have known that the price tag at the store would be over $900, he was able to advise the court that the Beretta had a time-proven design. He also stated confidently that this firearm had a recovery time that was very fast. He likewise had some information about each of the items he acquired in his second batch of purchases on May 25th, 2012. He explained that one attractive feature of the Bond Arms Ranger 2 was that after firing, the hammer jumps back into a half-cocked position for safety. He stated that it is also easier to clean because of the internal locking mechanism, although he conceded that he's never actually fired this gun and does not have any cleaning materials. Okay, I mean, does not have cleaning materials kind of, to me, doesn't suggest somebody who's actually doing much with their guns. As indicated, the defendant testified that he's not very experienced at shooting his weapons and only occasionally goes to a firing range with the guns. He testified that he preferred to keep them in pristine condition so they would be more valuable to his collection. Another of the guns that he purchased on May 25th, 2012 was a Jericho Baby Eagle, which he was able to describe as the smaller version of a more well-known firearm, the Jericho Desert Eagle, made by the same manufacturer. On this occasion, he also purchased a Charter Arms Target Bulldog, which he described as having a classic look with a rubber grip and stainless steel finish. He testified that Charter Arms is known for high quality at affordable prices, and that this gun had a simplistic design and has a reputation for being trouble-free operationally. You can see that his descriptions start sounding like maybe marketing material and less sort of how gun owners describe their guns. But carrying on, the defendant's testimony went on much like this, providing some information for each of the 23 guns he bought. The Browning Buckmark Camper, purchased on May 30th, 2012, was described as having a crisp, clean trigger with easy pullback. Again, that really sounds, that sounds straight out of a brochure. The defendant testified that he knew that this particular handgun was featured in Nazi-era propaganda, which he said he learned about in history class. The Sig Sauer, which he also purchased on May 30th, 2012, had what the defendant described as a lot of features that made it a very personal model for me. These included a double diamond grip, scales above the grip making it easier to handle when racking it, and a cheap price for a high-quality weapon. Smith & Wesson M&P 9 that he bought on June 15, 2012 was an interesting one, according to the defendant. He testified that this is a very efficient gun which is known to offer no surprises. He explained that this manufacturer is a huge and reliable company. In the defendant's words, Smith & Wesson is the Microsoft of the gun companies. They make very large deals, he added, and gave the example of a deal apparently made with Bill Clinton, although he did not elaborate on what Smith & Wesson's negotiations with the former president entailed. So, we can see the court is already kind of skeptical of his examples here. I'm going to skip on past, although they give an example. He buys a Beretta PX4 Storm, which he says has a lighter magazine than his other Berettas and was known for having good ergonomics. And then on July 27th, he buys yet another Beretta PX4 Storm with nothing that distinguishes it other than he testified that he just wanted to try something different, change of scenery. The difference, to be clear, was the store, not the gun. Most collectors aren't really buying sort of modern production stuff, and when they are, they tend to follow themes, whereas this guy's kind of jumping all over the place. And, you know, this doesn't seem like collector behavior when we look at it, and the judge already is thinking this doesn't really sound like a collector either. So he bought a Glock 17 Gen 4, which he indicated has a double spring guide ride system that reduces the recoil. Again, we see that he's kind of sounding more like he's talking marketing materials. He's reading brochures. Buys more guns. He's talking about how he bought a Walther P99, which he described as being featured in many James Bond movies and in the James Bond GoldenEye video game. Now, I could totally see somebody collecting firearms and saying, I'm collecting firearms that have been featured in movies or featured in video games, but typically that would be their example for all of these things. You know, you might say, I bought this one because it's from this video game and I wanted to collect that. And I bought this one because it's from this other video game and I wanted to collect that. Not sort of jumping around. He also testified that when Hitler committed suicide, a Walther was found next to his body. On the witness stand, the defendant explained that, without meaning to offend, Hitler was a very famous man. As he put it, I take pride in being a man of history. Funny how they always go to Hitler when that's where they're going, but anyway, moving on. So they sort of continue going through his guns for a while here, but in cross-examination, counsel for the Crown confronted the defendant with the fact that they were dangerous weapons and not collectible works of art or historic relics. The defendant stayed true to his academic discipline and gave a dialectical, if sometimes overused, response to Crown counsel's line of questioning. Question, your guns are dangerous, right? They can kill people. I don't know if this is the right forum to get into a philosophical discussion of whether guns kill people or people kill people. I don't really know about this particular angle of questioning because firearms collection is recognized in the Firearms Act. It's recognized as a thing that people can do. And of course, firearms can be dangerous, but people can collect all sorts of things that may, in fact, be dangerous in some fashion. Now, diving in, they say the defendant's finances. Crown produced the defendant's bank records from TD Canada Trust, and they form an exhibit at trial. And there's also bits from the agreed statement of facts that confirm from his known sources of income, the defendant could not afford the firearms purchases he made during 2012. As outlined in the agreed statement of facts, he worked part-time at Walmart and at Famous Players Theaters for most of the relevant months. So he's got two part-time jobs bringing in not a whole lot of money, and yet he's spending a lot on guns. So during the heavy firearms purchasing months of May to September 2012, he never earned more than slightly over $2,000 per month from his employment, and during the May-September buying spree, he spent more on firearms each month than he earned, to say nothing of his other expenses in life. He spent a total of $16,547.84 on firearms purchases during this 5-month spree. The defendant testified that there are two sources of income that do not appear in his bank records. The first of these are welfare checks, which he managed to receive by hiding from the government his employment status. This is never, I mean, this is something that happens. And, if you're up on the stand, you've got to, you've got to be honest if that's where your income is, but when you're making the decision to get up on the stand, you have, and that one of the things you're going to be testifying about is about how you've been lying to the government about your income for benefit. That already kind of tanks your credibility before you even open your mouth. So this is not a great thing here. He testified that he received $685 per month from welfare from January 2011 to July 2012, when he was not eligible because of his part-time employment. In all, he received 19 welfare checks for a total of $13,015 in income. None of these funds appear in his TD Canada Trust account. Shortly after buying his first firearm in January 2011, the defendant moved to his uncle Alfonso Smith's residence located at 20 Chipmunk Avenue in Scarborough. He testified that he did not want his uncle, with whom he was residing at the time, to know he was collecting welfare, and so he went to great efforts to always check the mailbox before anyone else got there. In his examination in chief, he stated that he had taken his uncle's mailbox key and had made his own copies so he could check the mail himself. And this is wonderful. The Crown did a really good job here on cross-examination, we can see, because they say in cross-examination, Crown Counsel put to the defendant the mailbox key that the police seized from him upon his arrest. At that point, the defendant had to concede that this was, in fact, an original key with the Canada Post markings on it. He then changed his story slightly and indicated that he just remembered that he took his aunt's key since she rarely used it and had not, in fact, made a copy of his uncle's key. Hey, I just remembered that the story I told you is a complete fabrication on this point. How's his credibility sounding so far? Is this guy sounding like somebody that the court is going to be on board with? Maybe not so much. This is, the Crown did good work in spotting that, because the Crown probably wasn't anticipating this story of the copied mailbox key. But it's lucky for them that they had in their, their file the details of this mailbox key, because that's devastating right there. That is not something you want to have happen to you on the stand. And the way you avoid that is you don't lie on the stand, because, or you make sure that you're telling the story accurately, because this is bad. Second source of invisible income that he says he earned is from casino gambling. The defendant testified that he became a very good card player, which he first learned by playing online. He indicated that he got into the habit of frequenting Falls View Casino in Niagara Falls. At one point, he said that he was seriously considering becoming a professional poker player. He testified that poker is easier than working. Curiously, this ambition seems to have run concurrently with his interest in philosophy. The defendant stated that he had unrecorded and unreported winnings from the casino, and that this explains his having in 2012 substantially more purchasing power than his income would have allowed, even taking into account the welfare payments. In his testimony, he played up the invisibility of this income as if it were a trump card that the Crown was powerless to counter. Do you think the judge is on board? I don't think the judge is on board. Continuing on. In effect, however, the casino story was more like a house of cards, and it folded under cross-examination. The judge is here. We can see the judge is being a little playful with the language here, because obviously the judge does not like the evidence that was given. So again, as a person who appreciates judicial snark, I am a fan of this particular bit here. In order to give the story any credence, one would have to believe that the defendant drove to Niagara Falls on a regular basis without anyone knowing, except the first time when he said he went with his cousin and a friend, neither of whom came to testify. That he never filled his car with gas or ate anywhere that provided a single receipt, was never seen or recognized by anyone while winning thousands of dollars, consistently came out ahead at casino games, never got a casino card for the casino's free drinks and meals, and spotted himself for his own first gambling stake by drawing $500 on his Visa card, and then forever afterwards played with his winnings. Crown Counsel suggested, with some cogency, that the casino story seemed tailor-made to fit his need for an untraceable financial explanation. In my view, there was little credibility to this entire aspect of his testimony. The defendant would have no reason to hide any Niagara Falls trips, and yet they were unusually invisible and unverifiable. Moreover, if I can put it this way, the odds are very much against anyone having the supposed gaming prowess that the defendant claims for himself. In my view, in trying to explain where the money came from to finance his firearms purchase, the defendant overplayed his hand. I love it. This is wonderful judicial snark here. And, but the other thing, just in terms of all of this, if I was this good at poker, there is no way you would find me working for, Walmart and Famous Players, because why are you going to go work, for 8 hours or whatever at a minimum wage job when you're instead making thousands of dollars at the casino? I just can't explain why somebody would do that if you have the ability to generate these thousands of dollars in what I imagine is a much more fun way. I've never actually talked to a professional poker player, but I assume they're still having fun when they're doing it. So it's probably more fun if they're winning on the regular. So storage of firearms. It keeps getting worse here. According to the defendant, all of his guns were stored at all relevant times in a proper firearm storage safe in the basement of his father's house at 7669 Kittredge Drive. This was the address at which the defendant resided with his father and 3 siblings when he received the license, and was the only place in the province that the defendant's firearms license allowed them to be stored. The defendant testified that the weapons were stored under lock and key, as the applicable safety regulations require. The agreed statement of fact indicates that the defendant's firearms were never legally moved from the address where they were stored. And so, basically, he never got an ATT in order to move them somewhere else. As indicated above, in early 2011, the defendant began residing at his uncle's house. The agreed statement narrates this relationship as follows. Justin had some trouble in high school. He hadn't finished enough classes to graduate, and many of the marks for the classes he had completed weren't high enough to get him into university. With his uncle's help, he managed to upgrade his marks and get his GED. He took night school classes and was able to get his marks up to a level where he could apply for university and reasonably expect to get in. While Justin lived with his uncle, he maintained his residence at his dad's house on paper. His driver's license, car insurance, etc. were all registered to his dad's Kittredge address, and at no point did he seek to change them. Further, after taking up residence with his uncle in 2011, at no point did Justin ever advise the Canadian Firearms Program that he'd moved residence. This last point, that he never applied to move residence to his new address for storage once he moved out of his father's house, was put to the defendant several times in cross-examination and argued strenuously by the Crown in final submissions. In response to the cross-examination questions, the defendant stated that the move to his uncle's coincided with his studying for his GED and his application and admission to university. He said that the uncle's place was akin to his student address and that he still considered his father's house to be his permanent home address. Counsel for the defense pointed out in argument that, in fact, there's no obligation to advise the firearms registry when a licensee moves. The firearms license is issued with respect to a specific address, but it can be the licensee's home, commercial or work address, warehouse, cottage, or for that matter, family home, as opposed to the licensee's current apartment or student residence. Defense counsel appears to be correct on this point. The license requires that the guns not move without permission. It does not require that the licensee not move without permission. If the defendant left the firearms stored properly at 7669 Kittredge Drive when he moved to 20 Chipmunk Avenue, he did nothing wrong in terms of his license. Now, we can discuss this in another video. This is just sort of the findings here. So that, however, begs the question of whether the guns were in fact stored at the Kittredge Drive residence. No one saw them there. The agreed statement of facts states that the defendant's father saw him come home with his first gun in January 2011 and relates their conversation as follows. After Justin purchased his first firearm in January of 2011, he attempted to bring it home to 7669 Kittredge Drive. He advised the officer that he told Justin that under no circumstances would he ever be permitted to bring a firearm into his home. He told Justin to take the firearm away, and he never saw or heard anything about it again. According to the defendant, the guns were stored in a crawl space in his father's basement. He testified that he did not tell anyone about their presence there for the sake of the safety and security of their storage. The defendant says that they were stored in a firearm storage safe, 5 feet tall by 2 feet plus wide, that he bought at Canadian Tire. He stated that he transported the safe from the store and brought it into the house by himself when no one was home. He has no receipt from the safe. Of course, that's not super uncommon that people wouldn't keep a receipt for things, but regardless, he doesn't have a receipt for it. He also said that he brought each of the firearms into the house without anyone seeing them, and that he racked them and locked them into their storage place without anyone hearing or seeing anything. Again, the defendant testified that he operated in such a way that was utterly invisible to everyone around him. Although he said he was a collector who loved admiring and playing with his firearms, he also said that he stored them in a way that ensured that he could virtually never take them out to even look at them, let alone to display them or take them to a firing range. The guns each came from the store with a lock for storage, and indeed the defendant had a number of keys for these locks in his possession when he was arrested. However, there were not as many keys as there were firearms. Again, this isn't super uncommon because people quite frequently buy key-like lock sets, so I don't know what we can make of that. However, this guy's credibility is not the greatest in any event. The defendant stated that he often checked on his weapons in storage to ensure that they were all there and that everything was in good order. He never noticed that anything was amiss or that any of his guns were missing until he was advised that all of them were missing in October 2012. However, Toronto police had found a Jericho Baby Eagle handgun in the possession of a suspect during the course of a drug arrest on June 15, 2012. After working for several months to restore the defaced serial number, the police determined that it was the weapon that the defendant had purchased several weeks previously on May 25th, 2012. It took them several months to restore the defaced serial number, so we don't know what time that was, but we see that May 25th to June 15th is not a long window. So on October 22nd, 2012, a search warrant was issued and executed in respect of 7669 Kittredge and the firearms that were supposed to be stored there. The agreed statement of facts describes the results of this search. Officers executed the warrant. No one was located in the house at the time the search was conducted. Officers searched the house from bottom to top, but did not locate any of the remaining 22 firearms that he'd purchased and registered to that address. There were no trigger locks located, no gun safes present, no receipts from any of the gun stores, and not one gun box was found. There was absolutely no evidence that any firearms had ever been brought into that residence or ever stored at that home. In fact, officers were unable to locate his firearms license. Shortly after the completion of the search warrant, they received a phone call from Elvis Green, the father. He advised police that his son had recently moved to 20 Chipmunk in the city of Toronto and was attending classes at U of T. And so they got a warrant for that address. Officers were unable to locate any evidence that firearms had ever been present at this residence either. There were no firearms, trigger locks, receipts from the 4 gun stores he'd purchased the guns from, or gun boxes. And the one safe that officers located in the residence contained Alfonso's good shoes that he didn't want Justin to wear. I'm just going to stop on that one. We've got this guy who's, supposedly this upstanding guy, and his uncle is locking away his good shoes to keep the guy from wearing them. I've never heard of such a thing. Who locks away their shoe? Anyway, that just seems like a weird thing to me. So in Justin's bedroom at 20 Chipmunk, they located his driver's license, firearms license, passport, etc. According to the defendant, the guns had vanished along with the safe and everything else that came with them. He testified that he had no idea what happened to any of it, and that as far as he knew, no one was aware the firearms had been stored at the Kittredge residence. When asked whether gun cleaning materials were also missing, he indicated that he never had any cleaning materials. As he put it, "I didn't want to make myself detectable." He also indicated that he never kept any of the receipts for the gun purchases because he didn't need them. Oddly, there were no signs of a break-in or robbery of the Kittredge house other than the missing firearm safe with all of its contents. No one has ever been arrested in respect of any break-in at the house. The agreed statement of fact confirms that at no point did Justin Green ever report a break-in, nor was a break-in ever reported at either address. So what we're talking about here, if we can sort of imagine this, is a group of Ocean's 11 style bandits who get into the house without tripping any security, without breaking anything. They must pick the locks, and clearly the only thing they're taking is a gun safe in its entirety, which was stored in a crawl space, which, of course, is going to be a bit of a pain to get in and out, with its complete contents, but they don't stop to take any other valuables. They don't anything else. They don't even leave footprints that might, muddy footprints or anything that might tip anyone off. So, does this sound like burglars to you? I don't think it sounds like burglars to the court. The defendant testified repeatedly that every time he bought a new gun, he immediately went to the Kittredge Drive address and placed it securely in the safe. That way, with each new purchase, he was also able to check that the guns he'd already stored there were all present and accounted for. Till the search warrant was executed in October 2012, the defendant says that he never noticed anything missing or otherwise amiss in his storage safe. He says that as of the date of his final firearms purchase on September 14th, 2012, all of his firearms were properly stored as usual. Have you spotted the problem? Because the court spotted the problem. He's about to get the hammer dropped down on him. Crown points out that this Jericho Baby Eagle was found at a crime scene on June 15th, 2012. This was only partway through the defendant's buying spree from May to September 2012. As of June 15th, 2012, he had only purchased 7 guns. He purchased 3 new guns that very day and testified that he took them to the address and put them in the safe. The defendant's story is seriously challenged by the fact that one of his firearms was recovered by the police prior to his having purchased the majority of his firearms. It is one thing for the defendant to say that he did not notice one of his weapons was missing from the safe. It takes matters to another level of credibility for him to say he did not notice one of 7 weapons missing. In any event, in order to account for the Jericho Baby Eagle being missing along with later purchases, there would have to have been not just 1 break-in, but 2. That is rather hard to fathom. It is hard enough to believe that 1 break-in could occur where a single firearm was removed from a locked safe without anyone noticing. It strains all credulity to think that there could have been 2 break-ins, the second of which removed not only the rest of the firearms, but the entire safe. And I mean, sometimes you do see this where they break in and they encounter a gun safe and then they come back later to try to attack the gun safe, bringing tools and equipment. So if you experience a break-in and they don't get into your gun safe, it's prudent to move your firearms to another location because there might be a round 2 planned that you just don't know about. But here, you've got to think, if they break into the gun safe, even if they don't have, anything, you think they'd at least take more than 1 gun. 7 guns is not, especially 7 handguns, you could fit that into a pillowcase and carry that out on your back. So the story just doesn't make a whole lot of sense to me, and it doesn't make a whole lot of sense to the Crown, and it doesn't make a whole lot of sense to the judge. And I'm sure the defense lawyer was trying his best here, but you can only do so much with what you've got. You can only work with the evidence you've got and with the witness you've got. And it's clear that his client wasn't doing him any favors. So a valiant effort on the part of the defense lawyer, but his client sunk him. That's the end of this one. So circumstances surrounding the defendant's arrest are not particularly important in respect to the offense's charges. However, he made a point of testifying about his arrest, and his evidence in this regard certainly goes to his credibility. Do we think it's going to go up or down? I know where my bets are, and I'm not as good a poker player as the defendant claims to be. So the search warrant was executed at the Kittredge address. The defendant's father called him to tell him what had transpired and that the police were looking for him. In his examination in chief, the defendant said that he had a sociology class and that he then went to the gym to play some basketball. He was finally arrested 3 days later on October 25th, 2012. He said that he called everyone he could think of to ask where the guns are, but has come up with nothing. That seems like a weird thing to do, to call people around, because who would you think to call if your guns were stolen? That makes no sense to me, unless maybe there were some people who might have your guns. So in cross-examination, the defendant's tone and story changed significantly. Crown counsel suggested to him that a person who has just been told that their firearms collection was missing might be worried about where the guns have gone, and that one might expect him to be concerned enough to call the police right away. Police wouldn't be my first phone call here. Lawyer would be my first phone call. Police would probably be my second phone call because, at this point, there's a warrant out. You probably want to get that dealt with. But, yeah. The defendant's response to this cross-examination replaced the basketball court with the library. He said that when he got the call about the search warrant from his father, he did not immediately call the police because he wanted to first go to the library to educate himself on the legal system and the law relating to bail. He also stated that he had a sociology exam coming up and that he was overwhelmed with anxiety about the exam. He testified that he took the exam and got an A. You know who can help you with the law relating to bail and the legal system? Lawyer. He should have called a lawyer at this stage. But so when he was arrested, the defendant was in possession of a cell phone. Counsel for the Crown observes that for a gun collector, it is odd that there are no photos on his cell phone of his gun collection. She suggested that for a person who professes to collect firearms for their aesthetics, he does not seem to want to partake of this aesthetic pleasure or to put it on display, even through photographs. I don't know if that's the strongest argument, but at the same time, I have some pictures of my guns on my phone, so I'm not sure if this is just, maybe not the strongest argument, or if this is something where I should feel personally attacked, because, yeah, that one kind of landed a little close to home, I guess. So in response, the defendant said that he's just being safe by not advertising that he has a firearms collection at home. This is the same reason he did not tell his father or brothers about it, even though he says the collection was stored in their own home. He concedes that he deceived them, but says it was all for safety's sake. Again, when you're getting up on the stand to say, here's the thing, I've been lying to everyone I've ever encountered. I've been lying to my dad, I've been lying to my family, I've been lying to the government, but I'm totally telling the truth now. You're going to have an uphill battle. So, how do we think he's doing on this uphill battle? I'm thinking not so great. I really should have poured a scotch for this one. Anyway, recovered firearms. 7 of the defendant's guns have now been recovered. The facts surrounding these recoveries are set out in the agreed statement of facts and are therefore considered proven. Again, once you concede a point, in an agreed statement of fact, it's as if it was a finding of the court, essentially. The recovery by the police of the 7 firearms can be summarized as follows. So, Jericho Baby Eagle with the serial number scratched out, seized from a drug offense. Crime Stoppers tip led police to arrest an individual carrying a Charter Arms Target Bulldog on the grounds of a local high school. Serial number was defaced, but there's a restoration process that revealed it to be a particular thing. Emergency call regarding a shooting in a nightclub and seized a Beretta PX4 Storm. Serial numbers had been removed, but a second serial number was visible. Somebody didn't know enough about guns to take off the second serial number. Does that sound like somebody with an encyclopedic knowledge of guns or a Wikipedic knowledge of guns? I don't know. I would have loved to see some forensic evidence on the means of defacing of these serial numbers, because I'm wondering if it was all done with the same tool or with different tools, because that could suggest either the buyers are getting them or the seller is taking the serial numbers off. But Toronto police responded to a shooting in a barber shop and seized a Buckmark camper from one of the shooters. One serial number removed, second serial number was visible, and they tracked it back to him. Executed a search warrant as part of a drug and gun trafficking investigation, seized a Glock Gen 4, serial numbers were removed, and a serial number restoration revealed what the original was. Armed robbery. And, they, once again, serial numbers had been scratched off, but restoration revealed the serial number. So in each of these events, it was clear that the firearm ended up in some sort of criminal party's hands, and the serial number had been defaced, but was recoverable. That leaves the possibility that there may have been other firearms where it was defaced in a way that wasn't recoverable, or just that they're still floating around out there. So what is controversial between the parties is the fact that there is no evidentiary link, other than the guns themselves, between the defendant and the persons in whose possession the recovered firearms were found. The defendant testified that he does not know who these persons are, and the Crown has provided no additional evidence that they are known or connected to the defendant. So what they're saying here is, the Crown's case would have been much better if they had one of these people, there to testify to say, I bought the gun from this dude. So the defense argument here is, how can you say that he was selling these guns or trafficking these guns because you don't have any direct connection to that. There's no direct evidence on this. This is a purely circumstantial case. However, it is possible to convict on purely circumstantial evidence. Let's see where the court's going on this one. They say, that said, the circumstantial evidence is strong. The recovered firearms were all purchased by the defendant, and they had vanished from his possession in very suspicious circumstances. The defendant had exclusive opportunity to traffic in the firearms. He was the licensed purchaser who had taken possession of each of the firearms, and he testified repeatedly that he was the only person who knew that he had purchased and possessed them. The Crown submits that since he was the buyer and sole possessor of the recovered firearms, he must have been the seller and transferor of them as well. Whereas 7 of the defendant's firearms have been recovered, 16 of them are still missing. There is no evidence as to what has become of these 16 missing firearms. It says, I must decide this case on the basis of a number of fundamental legal principles. First is that the defendant is presumed to be innocent, and that the onus of proving the case beyond a reasonable doubt rests with the Crown. This is a proper statement of the law. However, it's a very pedestrian statement of the law, because this is sort of the basics. We'll get into sort of a little bit more of the analysis. It says, if I find that the evidence establishes a likelihood of guilt, or even a strong probability of guilt regarding any of the offenses charged, I must nevertheless acquit, as that level of proof does not meet the requisite standard of proof beyond a reasonable doubt. So he's saying it can't just be really likely, it's got to be this very strong test. And that's an important principle in the Canadian legal system. We want to minimize false convictions. They also say, in a case like this where the defendant has testified on his own behalf, I must keep in mind that I need not firmly believe or disbelieve any witness or set of witnesses. And this is from the case of the Queen and WD, which is a really critical case on the evaluation of witness evidence. In sizing up the testimony of the defendant and the evidence presented by the Crown, I must proceed in accordance with the instructions suggested for such a case in WD. So this is sort of steps for analyzing situations where the accused has provided testimony that would, if believed, provide them with a defense. First, if you believe the evidence of the accused, obviously you must acquit. So if you believe the accused when he says he didn't do it, then you got to acquit on that basis. Second, if you do not believe the testimony of the accused, but you are left in reasonable doubt by it, you must acquit. So what that means is you might think that the accused is, a liar. However, the story might still be plausible. It might still be possible. It might still raise a situation that the Crown has not managed to squash out through their evidence. And in that case, you also must acquit. Third, even if you are not left in doubt by the evidence of the accused, you must ask yourself whether, on the basis of the evidence which you do accept, you are convinced beyond a reasonable doubt by that evidence of the guilt of the accused. So, even if the accused evidence is complete garbage, you still have to determine, has the case been proven? Now, I like these steps. I don't like necessarily the order where they're usually presented, because to my mind, the third step here should be the starting step. As a starting place, if the Crown hasn't established their case, then it doesn't matter whether you believe the accused or not, unless the accused has offered something that is an admission. If they've confessed on the stand, then, that's a different scenario. But, so I don't think these are necessarily in a strict order, but this is a very fundamental and important case. So the evidence must be considered in its totality. Mere disbelief of the accused's exculpatory account or mere preference in favor of the complainant's account does not equate with guilt. So it's not a situation where if you've got a he said, she said story, you can't just say, well, I like this person's evidence a little better, so I'm going to convict. Or, it's got to be sort of, again, the proof beyond a reasonable doubt standard. On the other hand, I must also keep in mind that the standard of proof beyond a reasonable doubt does not involve proof to an absolute certainty. It is not proof beyond any doubt, nor does an imaginary or frivolous doubt. So if your defense is something like, maybe a wizard did it, that's not going to fly here. Or maybe this Ocean's 11 style, burglary crew was targeting my house and stole one gun one time and then everything another time and weren't interested in any other valuables, we're starting to get into what sounds like an imaginary or frivolous doubt to me. So that's kind of the consideration there. I may find the defendant guilty if the evidence allows me to come to a determination as to exactly where the truth of the matter lay. I did not find the defendant to be a credible witness. You don't say. His examination in chief was smooth and sounded well rehearsed, especially with respect to his knowledge about the individual firearms. However, in cross-examination, he revealed many contradictions, mistakes, changes of story, and apparent fabrications. His ability to suddenly remember that he'd taken his aunt's original mailbox key and that he'd not actually made a copy of his uncle's key, which he'd gone out of his way to explain in chief, was emblematic of much of the cross-examination. In chief, he went to play basketball after hearing about the search warrant executed at Kittredge. In cross, he suddenly went to the library to study up on the law of bail. In chief, he was strictly a collector of firearms. In cross, he suddenly realized that he had made a mistake when he answered no on the RCMP license application form that asked if he is a collector. Whoops. His testimony was replete with answers and follow-up answers like these, leaving the impression that the defendant has an overly clever answer to just about anything. Lots of people think they can, go into a courtroom and lie and convince a judge. Lots of people find themselves being very wrong because judges are very used to this. And, lawyers, one of their jobs is catching liars in lies and tripping them up in cross-examination. This guy got he got he got destroyed is what it comes down to. He just got flattened. So most importantly, even where the defendant has not been specifically contradicted or where he has not attempted to correct or revise his story after the fact, his evidence is simply impossible to believe on a number of crucial points. This is especially the case with respect to the supposed storage and disappearance of the firearms themselves. In the first place, his income during the crucial May to September 2012 buying spree was $7,072.50, and during this period he spent $16,500 on guns. Is one of these numbers bigger than the other? Do you think the court is going to have a problem with that? Of course they are. His explanation with respect to the welfare fraud might be credible, although it reveals fundamental deceitfulness. Yeah. Hey, I'm a liar. Believe me in court. But his further explanation about the casino winnings that no one else knows about and for which there is not a single shred of evidence showing even a fleeting visit to the Niagara Falls area is so improbable as to lack all credibility. The inevitable conclusion to be drawn from all the evidence is that he could not afford to buy the guns that he bought. I mean, if I was, let's say I was actually some sort of secret gambling wizard and, I'm pretty sure that I could drag together some evidence to confirm that. Go in there, find somebody who dealt cards at one of the poker tables where you were winning all this money. Somebody who can come in and say, yeah, you know what? He sat down and he cleaned house and, was raking in the dollars. Never seen anything like it. But he doesn't have that. And I assume, he probably doesn't have that because as the court concludes, it never happened. So furthermore, it may be theoretically possible for a person to have bought, transported, and stored in his family home 23 firearms without anyone knowing, but it is highly unlikely. The evidence is that racking a firearm in a storage safe makes a significant amount of noise, and storing 23 firearms properly takes some logistics. In theory, it may also be possible, but even less likely, for a person to have bought, transported, and set up in the basement of the house a metal storage safe that was 5 feet tall and 2 feet wide. The defendant testified that he had use of a car, but did not have a truck, and he would have had a struggle transporting the safe to the house. And that is to say nothing about carrying it into the house and down the basement stairs alone. Now, I find myself wondering what sort of safe he's saying he has here. Is he talking about the Canadian Tire sort of sheet metal variant, or is he talking about one of the more heavy durable ones? Because if he's saying that he transported one of those more heavy durable ones on his own and got it through the house, I don't think so, unless this guy is built like a truck. Maybe he should have actually testified that he got his money winning strongman competitions. What approaches the impossible is that there would be a robbery in which all of the guns in the defendant's basement were stolen without him having noticed. The firearms that have been recovered from the defendant's collection were found at crime scenes and in the hands of unrelated individuals elsewhere in the city. The thieves would not need a regulation safe for storage and would doubtless dispense with removing from the house something so large and visible when they could simply take the handguns. Now, that's not necessarily the case, because sometimes what happens is people steal the entire safe because they can't get into it at the time, and then transport it somewhere else where they will have the luxury of time and in a place where people aren't going to notice the noise, and then they can spend a while with tools to get into it. However, if that isn't enough, it is so improbable as to be virtually impossible to take seriously that the thief or thieves that stole the first gun before or on June 15, 2012, then came for the rest of them on or after September 14, 2012, and even took the safe in which they were stored. In addition, there is no reason for thieves to try to scratch out the serial numbers of the firearms. Counsel for the defense suggests that the theft may have been a member of the defendant's father's household, thus explaining the lack of any other signs of a break-in. That is an interesting theory, although it begs the question of why the defendant's brothers or father, who lived at the address, would need a storage safe and where they would put it. More significantly, there's not one shred of evidence in the record to support this theory. The police interviewed the defendant's father and conducted an investigation of the household and apparently found no such evidence. Moreover, the defendant himself insists that neither his father nor his siblings were aware of the guns being in the house. I also find it very difficult to believe that the defendant was a collector of firearms in any real sense of the word. In the first place, there's evidence that on the RCMP firearms application form, the defendant ticked no where it asked if he is a collector. The defendant says that this was a mistake on his part. He's making a lot of these really convenient mistakes, isn't he? But his evidence does not make it look like a mistake. He has the kind of knowledge about the guns he bought that he could have acquired at any time, including just before trial. Ooh, I love that remark. That's cutting. By perusing the internet for a few minutes on each weapon. That's real. The judge is being really insightful here in a way that I appreciate, because, I win or lose, I want to see that judges have engaged with the evidence and that they've come to a verdict, based on that and based on proper application of the law and good consideration. In this case, I cannot fault the judge's reasoning. He's seeing right through this story, and he's being very careful to indicate how and why he's seeing through this story and why he doesn't buy it in the slightest. So, continuing on, the defendant bought multiples of various firearms and even bought several of his guns used rather than new. None of the firearms were collector's items in that they were all modern mass-produced weapons. Moreover, the defendant claims to have stored them in a way which belies being a collector. Also, he says he's not firing them to keep their value, but they're modern mass-produced firearms, and he's buying them used. I don't know about that. Anyway, strains credulity for a hobbyist collector to say that he operates in absolute secrecy and under circumstances that don't even allow him to take out the guns or even look at them. He insists that the guns are a hobby collection, but the hobby amounts to virtually nothing. And also, gun collectors tend to want to talk to people about their gun collection. There tends to be sort of a social aspect to it, so I don't see that here. I conclude from all of the evidence that the defendant never stored his firearms at his father's house. The question remains is, what did he do with them? The Crown has demonstrated that 7 of the firearms ended up illicitly in the hands of others. While there is no evidence directly linking the defendant to any of the individuals from whom the recovered firearms were seized, the evidence of the defendant's conduct establishes that he had purchased the weapons with the intent of reselling them. This is the only way he could have financed the purchases, and this explains the fact that a large safe has also vanished from the Kittredge Drive house, i.e., it was never there to begin with, as the firearms were purchased by the defendant to be passed on to others and did not need to be stored for long term, if at all. Counsel for the Crown summed up her position with the curt observation that there's no possible explanation for any of this. Those guns ended up on our street because Justin Green sold them. This is effectively a reiteration of the rule with respect to circumstantial evidence as set out in Hodge's case. As restated by the Supreme Court in Arsenal, the trier of fact must be satisfied beyond a reasonable doubt that the only rational inference that can be drawn from the circumstantial evidence is that the accused is guilty. Really a high test here. In my view, this is an apt description for the defendant's conduct here. Given the evidence demonstrating that he could not afford the firearms he bought without reselling them, that he never stored them, and that he never really had a safe or facility in which to store them, that he did not purchase or display guns like a collector would do, and that the weapons vanished without a trace until 7 of them were found in the possession of other persons at crime scenes or in the course of police investigations, there is no other conclusion to be drawn. The defendant purchased the firearms in order to sell them. I can do no better than to say, as the Supreme Court of Canada has said, the facts are such as to be inconsistent with any other rational conclusion than that the accused is the guilty person. I find that the defendant transferred the 7 recovered firearms contrary to Section 99 sub 1 sub a of the Criminal Code. Given that the defendant's other 16 firearms have not been located, there is not conclusive evidence that they've been transferred to anyone. They are missing, and one can deeply suspect that they've been trafficked in much the same way as the recovered firearms. They were purchased in the same months-long buying spree by the defendant. They were registered to him under his license. They were supposed to have been stored at the same location, and they vanished at the same time. Without recovery of those weapons or identification of a transferee, however, the most one can say is that the defendant possessed the 16 unrecovered firearms for the purpose of trafficking. Again, the evidence is capable of only one conclusion, that the defendant bought all 23 of his firearms with the intent and for the purpose of reselling them. The 16 missing guns were probably sold by the defendant, but for all we know, he could still be in possession of them, somewhere reserved for future sale. So he couldn't, we can see, convict on the actual weapons trafficking. However, he does convict on the possession of the 16 unrecovered firearms for the purpose of trafficking them, contrary to Section 100 sub 1 of the Criminal Code. So finds the defendant guilty on all counts. Now, we don't actually have the sentencing in this particular guideline because it's this is just the decision on the actual on the merits of the charges. So the sentencing would happen at another point. However, this is a really interesting case. It provides an insight into an example of somebody who's engaged in straw purchasing and shows us how they can, find this fairly readily and they can take this apart. So this guy will, I expect, have gotten a very lengthy sentence because this sort of trafficking for profit is something the courts actually view very harshly. So they, I'm going to bet that the money he made on this was A, burned on his legal fees, and B, he's not going to have enjoyed what's happened. He had aspirations of becoming a lawyer. I can tell you, with a conviction like this for weapons trafficking, the odds of him becoming a lawyer are just about nothing. I just don't see it happening. I don't see a law society saying, yeah, okay, we'll take you. That seems okay now. So he really burned his life to the ground. And for, at the end of the day, a very small amount of money. It's when you actually tally up everything that he would have gotten from this, it's not all that impressive. But I love this case, in part because of the insight it provides, but also I have to admit it's a really something of a guilty pleasure because watching how the court, tackles this and watching the court's very thorough takedown of this evidence and how they just, right from the beginning, the court sort of says, let's start poking some holes in this. Let's examine your story on its merits and, give you the full chance. But it's clear that the court did not find this person to be an honest witness, to be a credible witness in any form, and smacked them down accordingly. I can also pretty much guarantee you that when it comes time for sentencing, the court is going to probably, even if they don't explicitly consider their findings about what happened on the stand in their sentencing, it's going to weigh in because, a judge is human. Judges are people. And when you get up on the stand and you form, you convince the judge that you are this kind of weaselly person, it's going to weigh into their assessment of, for instance, how much you can be rehabilitated. And whether, a sentence that preserves your career prospects is something that's in the interests of society. I kind of feel the the judge is going to be inclined to say no. This is a situation where the accused might have been better off, where they said, where, you know, a guilty plea was entered and some acceptance of responsibility was taken. But ultimately, you know, the accused has the right and every right to run the trial. But ultimately, this one didn't work out for them for fairly obvious reasons. So thank you for watching. I hope you enjoyed this case as much as I did. This is just, it's a fun case. And this was one I thought I would do as sort of a quick case, and it's not a quick case. This is going to be an hour's worth of video, but I hope you've enjoyed sort of seeing this judicial smackdown. That's really how I can put it. You note that the judge doesn't have anything bad to say about the defense lawyer, and I don't have anything bad to say about the defense lawyer either. The defense lawyer did their best with what they had, and, you know, the blame on this one rests squarely with the witness, who is also the accused. So thank you once again for watching. Please like this video. Please share it with your friends. Please subscribe to see more content. I also want to thank my Patreon supporters at the $50 level: Demo, People of Canada, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, Toronto Airsoft, and Rail. At the $20 level: Cameron Johnson, Kevin Fleet, and Dale Nesbitt.